And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
Imagine this scenario. You are driving home. You're a law-abiding gun owner. You have your concealed carry permit. Everything is legal. Everything is above board. Then the blue and red lights flash in your rearview mirror. Your heart rate spikes immediately. The officer approaches. He asks the question that changes everything. Do you have any weapons in the vehicle? If you say the wrong thing, or even if you simply say nothing at all, you face confiscation, search, felony charges, and the catastrophic loss of your freedom. This is not a drill. It happens to thousands of licensed gun owners every single year. But there are 5 specific words that create an immediate, impenetrable legal shield between you and prosecution. They stop the interrogation dead in its tracks. They force the police to back down or risk the entire case being thrown out. We are going to dive deep into the specific legal precedents you must know. We are going to look at the massive mistake that cost people their freedom, and it's not what you think. And we will drill those 5 specific words into your memory, because your silence can actually be used against you in court. That is the insane reality of the law right now, and you need to know how to fight it. Or ours, the fatal flaw, talking your way into handcuffs. The first mistake is almost universally common, the instinct to be helpful. Let me tell you about Michael. He's a concealed carry permit holder in Texas, a state known for being firearm friendly. Clean record, lawful gun owner, just like you. He got pulled over for something minor, a broken taillight. The officer asked clearly and casually, "Do you have any weapons in the vehicle?" Michael thought honesty was the best policy. He wanted to be cooperative, establish trust. He leaned forward and said, "Yes, sir, I have my pistol in the center console. I have my permit right here. I was just at the gun range. I always carry because you never know what could happen these days." He thought he was being transparent. He thought he was establishing himself as a good guy. 20 minutes later, Michael was standing on the curb in handcuffs. His car was being searched bumper to bumper. His legally owned firearm was confiscated, and every single explanatory, unnecessary word he had uttered was being recorded and used to build a potential case against him. Michael made the same mistake that bankrupts thousands of responsible gun owners every year. He talked too much. When that officer asks about weapons, he is not making conversation, he is gathering evidence. He is looking for a reason to escalate the interaction from a simple traffic ticket to a full custodial arrest. He is legally fishing. Every phrase, every nervous explanation, every volunteer detail is being analyzed and potentially twisted against you in court. You might be in a state that requires you to disclose that you are armed. We will cover that critical nuance later. But that disclosure is not an invitation to explain your life history. It is a one-sentence legal requirement. Period. Anything beyond that single statement constitutes self-incrimination. Under the Fifth Amendment, you have the right to remain silent, precisely because answering police questions could lead to comments that could and will be held against you. But here is the massive hidden problem. Most people do not know how to use that right properly. The pointing trap and implied consent. Let's look at another victim of good intentions, Sarah, who learned this devastating lesson in Florida. The officer, sensing an opening, changed his tone and asked, "Okay, where exactly is the gun located?" Sarah pointed to her glove box. She thought she was being helpful. She was trying to show the officer she was compliant and that the weapon was secured. What she actually did was give the officer legal voluntary consent to open that compartment. That action, the pointing, waived her Fourth Amendment rights against an unreasonable search of that specific location. Inside the glove box, the officer found her firearm, her permit, and a small bottle of prescription medication that, critically, had no pharmacy label on it. Now Sarah is facing drug possession charges because she pointed instead of staying silent. Think about this. When you point to where your gun is, you are authorizing a search. When you explain why you carry, you are creating evidence. When you volunteer information, you are building the prosecutor's entire case for them. You think you are being cooperative. They think you are handing them a silver platter of evidence. The state line roulette. The ever-shifting law. Mistake number 3 is failing to recognize that you are navigating a legal minefield that changes its shape constantly. Right now, in this current year, there are over a dozen states that legally require you to inform the officer that you are armed the moment he walks up to your window. These are called duty to inform states. Texas, North Carolina, Michigan, Nebraska, Arkansas, Louisiana. The list changes constantly. But here is where the real danger lies. These laws are constantly in flux. They are not static. Just last year, Ohio eliminated their duty to inform requirement entirely. Louisiana made their penalties stricter. South Carolina changed the exact wording you must use. Arkansas changed when you have to disclose the information. If you learned these rules 2 years ago from some dusty forum post, you might be breaking the law right now and not even know it. Ignorance of the law is not a defense, it is a conviction. And if you cross state lines with your firearm, you are playing Russian roulette with the law. You could be perfectly legal in your home state and committing a felony the instant your tires cross the state border. You think stand your ground laws protect you everywhere? They do not. You think your permit is recognized in every state? It is absolutely not. You think the rules for magazine capacity or firearm registration are the same? They absolutely are not. You must research the specific laws of every jurisdiction you enter. Relying on reciprocity maps found on gun forms is reckless. That information is often weeks or months out of date, and that delay can cost you 5 years in prison. The Supreme Court loophole: why silence is not protection. Now, this is the mistake that will genuinely blow your mind. This is the truth that separates those who walk free from those who get indicted. You probably believe that if you just stay quiet, you're protected by the constitutional right to remain silent. You are dead wrong. I can prove it with a landmark Supreme Court case that fundamentally changed the way the Fifth Amendment works during non-custodial police interactions. In 2013, the Supreme Court decided Salinas versus Texas. Here's what happened. Genevieve Salinas went to the police station voluntarily. He was not arrested. He just agreed to answer questions about a recent murder. He talked to the detective for nearly an hour. The detective then asked him a highly specific question: whether ballistics testing would match his shotgun to shell casings found at the crime scene. Salinas said nothing. He went completely silent. He never verbally asserted his rights. He just stopped talking. At his trial, the prosecutor used his silence, that pause, that look of sudden realization, as evidence of guilt. The prosecutor argued that an innocent man would have immediately denied the claim. Salinas argued that using his silence violated his Fifth Amendment rights. The Supreme Court, in a stunning and narrow 5-4 ruling, said, "No, it doesn't." Wait, let's look at that again. The Supreme Court said silence is not protection. Why? Because Salinas never said the magic words. He never explicitly invoked his Fifth Amendment rights. He just stayed quiet. And the court ruled that if you do not specifically invoke your rights, your silence can legally be used as evidence of guilt or consciousness of guilt. Think about the implications of that ruling. Your constitutional right to remain silent does not protect you unless you specifically announce that you are using it. It's like having a bulletproof vest in your closet while someone is shooting at you. The protection exists, but it only works if you put it on and explicitly state that you're wearing it. This is why just being quiet during a traffic stop can actually destroy you. Unless you invoke your rights properly, that silence becomes evidence used against you. The jury hears when the officer asked about the gun, he just sat there, didn't say a word, like he had something to hide. And you are done. Shirt starter. The 5 words that save your life. All right, here is what you came for. The 5 words that create a legal fortress between you and prosecution. Are you ready? Here they are. I invoke my Fifth Amendment rights. Not, I plead the Fifth. Not, I don't want to answer. Not, I think I should talk to a lawyer. Those exact 5 words. You say them clearly, you say them calmly, you say them firmly, and then you stop talking. Why these specific words? Because when you say, I invoke my Fifth Amendment rights, you are making an explicit constitutional claim that satisfies the Salinas versus Texas requirement. You cannot be ambiguous. You must be direct. Officers are trained to recognize this precise phrase. They know that anything they get from you after you invoke that specific constitutional right is likely inadmissible in court. They know that continuing to question you risks getting the entire case thrown out by a judge. They know that you just put up a solid legal wall they cannot easily climb over. But you cannot just invoke and then sit there looking guilty. You must immediately follow up with the second crucial sentence. This sentence protects you against accusations of obstruction or resisting arrest. You must say, I will fully cooperate once my attorney is present. This is critical. This proves you are not being difficult. You're not obstructing justice. You're simply exercising your constitutional right while simultaneously showing a willingness to help through proper legal channels once your counsel is present. Mid-video CTA. If you are finding this analysis helpful, please take a second to like this video and subscribe to Law Advisor. It helps us keep these deep dives coming. Now back to the case. Does Fierce applying the protocol. Duty to inform states. Now, if you are in one of those duty to inform states, you still have to disclose your carrying status, but you do it strategically and minimally. Here is your protocol. The moment the officer approaches, your hands go immediately on the steering wheel at 10 and 2. You do not move them. When he gets to your window, you say exactly this. Officer, I want to inform you that I have a valid concealed carry permit and I am currently carrying. Then you stop. You have satisfied your legal duty to inform. You do not say where the gun is. You do not say what kind it is. You do not say why you're carrying it. You do not say where you are coming from or where you're going. Everything else is optional, and optional means you must skip it. He will probably ask, where is the weapon located? Or, can I see your permit and the weapon? Here is your response. I invoke my Fifth Amendment rights. I will fully cooperate once my attorney is present. You have fulfilled your legal obligation to notify him you are armed. You do not have to answer interrogation questions. The statute requires notification, not a full interview or a voluntary search. Handling the search request. Eventually, the officer is going to ask, mind if I take a look in your vehicle? This sounds friendly. It is the opposite of friendly. It is a legal trap designed to make you waive your rights without realizing it. Under the Fourth Amendment, you are protected from unreasonable searches and seizures. For police to search your car, they need your permission, a warrant, or probable cause, meaning objective facts that suggest you committed a crime. When they ask, mind if I take a look, they're asking you to waive your Fourth Amendment rights. Once you say yes, they can search anywhere, and whatever they find becomes admissible evidence, even if it has absolutely nothing to do with why they pulled you over. Maybe you forgot about that loose round of ammunition in your back seat. That is evidence. Maybe you have a bottle of prescription pills in the console that slipped out of the original pharmacy bottle. Now they are asking if you have a prescription for those. The search escalates immediately. Your response must be simple, clear, and legal. Officer, I do not consent to any searches. Notice you do not say, I'd rather you didn't, or do you have to? You say, I do not consent. That is a legally firm statement. It is respectful, and it preserves your rights. If the officer says, well, if you have nothing to hide, why won't you let me search? Your response is this layered defense. I invoke my Fifth Amendment rights. I do not consent to any searches. Do not argue. Do not explain. Do not justify your decision. Just repeat your legally protected position. The nightmare scenario. After a self-defense shooting, let us talk about the ultimate nightmare scenario. You had to use your firearm in self-defense. You did everything right. The threat was real. The danger was imminent. You had no choice. Now you have to call 911. This is where even the most justified citizen can destroy their entire case. Your adrenaline is through the roof. You start talking. He came at me. I warned him. I had to shoot. I was so scared. He was going to kill me. Every word you say is being recorded. Every word will be analyzed for discrepancies, inconsistencies, and signs of premeditation or excessive force. Every word can be twisted against you by a prosecutor who was not there. Here is exactly what you say on that 911 call. You must stick to these 4 essential facts. 1. There has been a shooting at exact address. 2. I need police and EMS immediately. 3. I am the victim. The suspect is brief physical description. 4. I am armed and no longer in danger. Then you stop. That is it. The dispatcher will immediately ask you questions. What happened? Where's the gun? Why did you shoot? Your response to every single question repeatedly is, I invoke my Fifth Amendment rights. I will provide a full statement once my attorney is present. I know it feels wrong. You want to explain. You want them to understand that you are the good guy, that you acted legally. But here is the brutal truth. You're not going to talk yourself out of charges on a 911 call or in the immediate aftermath with police. You're only going to talk yourself into charges. Save your detailed explanation for your attorney, who will craft it and present it in a way that protects your legal standing instead of destroying it. Or versus your insurance policy, the recording strategy. Here is your insurance policy against procedural errors and police misconduct. Record the encounter. Under the First Amendment, you generally have the right to record police during traffic stops, provided you do not interfere with their duties. Pull out your phone, start recording video, and place it on your dashboard or lap where it can clearly see and hear everything. This recording proves what was actually said. It captures whether you properly invoked your rights. It documents any potential Fourth Amendment violations. It provides neutral evidence if there's a later dispute about what happened. Many officers wear body cameras, but you do not control that footage and it can be edited or lost. Your recording is yours. It is your protection. Practice until it's automatic. Right now, I want you to do something essential. Say these words out loud. I invoke my Fifth Amendment rights. Say them again. Say them calmly. Say them clearly. In a high-stress traffic stop, you will not suddenly rise to the occasion. You will fall to your level of training. If you have never practiced this phrase, it will not come out smoothly when you are nervous and a trained officer is standing at your window. Practice until you can say it confidently. Practice with a friend who plays the role of the officer. Practice until these words are so ingrained in your muscle memory that they come out even when your hands are shaking and your heart is pounding. Also, practice, officer, I do not consent to any searches. And practice, officer, I want to inform you that I have a valid concealed carry permit and I am currently carrying. These phrases need to be automatic. They are the keys to your freedom. You now know something most gun owners will never learn until they are sitting in a holding cell wondering where it all went wrong. 5 words that create a constitutional shield, 1 sentence that preserves your Fourth Amendment rights, and 1 truthful disclosure that satisfies duty to inform laws. Your continued freedom depends on knowing these words and having the courage and presence of mind to use them exactly when needed. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I'll see you in the next one.